Good afternoon, ma'am. Good afternoon, classmates. So, one of our topics for today would be on the basic rights and guarantees given to foreign investors as provided under the Omnibus Investment Code or the Executive Order number 226. So, under Executive Order number 226, we have four rights included under it. Four rights of foreign investors. First would be the right to repatriation of investments. Next would be the right to remittance of earnings, the right to freedom from expropriation, and they also have the right to non-requisition of their investment. So first, we have the right to repatriation of investment. So we have learned before that repatriation would be sending someone back to his own country. And we can also use such a term in investment. Um, it's somewhat similar because here the foreign investor is asking that the entire proceeds of the liquidation investment would be on the currency on his or her local currency. So for example, if he invested here in the Philippines, then um, then of course it will be on um, our our currency, which is Philippine peso. But when um, he will claim the proceeds of the liquidation of his investment, has the right to claim it on his her or her own local currency. That would be the gist of the right to repatriation of investments. And it should be made at the exchange rate prevailing at the time of repatriation. So the the one that should govern the exchange rate that would govern would be the at the time that exchange rate which is prevailing at the time of the repatriation. But such would be subject to the provisions of Section 74 of RA number 265. So what is included in RA number 265 would be this one: in order to protect the international reserve of the central bank during an exchange crisis and to give the monetary board and the government time in which to take constructive measures to combat such a crisis. The monetary board, but take note it should be with the concurrence of at least 5 of its members and with the approval of the President of the Philippines, may temporarily, so it will temporarily suspend or restrict sales of exchange, but it should be with the concurrence of at least 5 of its members and with the approval of the President of the Philippines by the central bank, and may subject all the transactions in gold and foreign exchange. So we are more concerned with this foreign exchange to license by the central bank. So the adoption of the emergency measures authorized in this one shall be subject to an executive and international agreement to which the Republic of the Philippines is a party. So, next right would be the right to remittance of earnings. Of course, when foreign investors invest, they are, of course, after the earnings that they will get. So, in the case of foreign investments, the right to remit earnings from the investment in the currency, so same, in the currency in which the investments was originally made. If the investment was originally made in the currency through in US dollar currency, then when he remit the earnings from such investment, then it should also be in the form of US dollar. And it should also be made at um, the exchange rate prevailing at the time of remittance. Remittance subject again to the provisions of Section 74 when there is crisis. So when there is a crisis, there will be a suspension first of the exchange in order to combat such a crisis. Next would be included in the right to remit earnings with the right to remit at the exchange rate prevailing at the time of such sums so as may be needed to meet the payments of interest and principal on foreign loans and foreign obligations arising from technological assistance contracts that the foreign investor entered into. And still, it will still be subject to the provisions of Section 74 of RA number 926 RA number 265 as when there will be crisis. And next, just like local investors and individuals who has the right to due process and the right not to be deprived of the proper process of law. Foreign investors also have that right, which is the right to freedom from expropriation. So here, no expropriation should be done by the government of a property represented by the investments or of the property of the enterprise that the foreign investor has invested, but except only for if it except only if it is for public use or in the interest of national welfare or defense. And of course, when there's expropriation, there should always be payment of just compensation. And in such a cases, the foreign investors or enterprise shall have the right to remit the sums received as just compensation for the expropriated property in the currency, again, in which the investment was originally made and at the exchange rate at the time of the remittance, but still, it will still be subject to the provisions of Section 74 of RA number 265. And the last right would be the right to non-requisition of investment. So here, this right pertains to the right of foreign investor to exclude his investments or property from being requisitioned by the government or from being taken by the government. But there will be exception, and the exceptions would be in the event of war or national emergency, and only for the duration of such war or national emergency. So, in the event that the property or represented by the investment of the foreign investor will be requisitioned by the government, just compensation shall be determined and paid either at the time of the requisition or immediately after the cessation of the state of war or the national emergency. And the payments received as compensation for the requisition property may be remitted again in the currency in which the investment was originally made and at the exchange rate prevailing at the time of the remittance. Still, it would be subject to the provisions of Section 74 of RA number 265. That would be all for this topic.
Good afternoon, everyone. Let us now discuss the different types of investment. So before we discuss the different types of investment, let us now first define what a registered enterprise is, which begs now to answer the question, who will be the subjects of the said law? So a registered enterprise shall mean any individual, partnership, cooperative, corporation, or other entity incorporated and or organized and existing under Philippine laws. It is registered with the board in accordance with the Omnibus Investment Codes and may either refer to the pioneer or non-pioneer enterprises and includes multinational corporations. So who are now not included in the said law? So it shall not include commercial banks, savings and mortgage banks, rural banks, savings and loan associations, building and loan associations, developmental banks, trust companies, investment banks, finance companies, brokers and dealers in securities, consumers, cooperatives and credit unions, and other business organizations whose principal purpose or principal source of income is to receive deposits, lend or borrow money, buy and sell or otherwise deal, trade or invest in common or preferred stocks, debentures, bonds, or other marketable instruments generally recognized as securities or discharge other similar intermediary, trust, or fiduciary functions. So let us now go to the first type of investment, which is the pioneer area of investment. Let us first describe and define what a pioneer enterprise is, which under Section 3H of Republic Act number 5186 is a registered enterprise engaged in the manufacture, processing, or production, and not merely the assembly or packaging of goods, products, commodities, or raw materials that have not been or are not being produced in the Philippines on a commercial sale. A pioneer enterprise may also mean one which uses a design, formula, scheme, method, process, or system of production or transformation of any element, substance, or raw materials into another element or finished product which is new and untried in the Philippines. Moreover, under Article 17 of the Omnibus Investment Code, a pioneer enterprise is also defined as one engaged in the pursuit of agricultural, forestry, and other mining activities and or services, including the industrial aspects of food processing whenever appropriate, predetermined by the board in consultation with the appropriate department to be feasible and highly essential to the attainment of the national goal. So a pioneer enterprise also includes one which produces non-conventional fuels or manufactures equipment which utilize non-conventional sources of energy or uses or converts to coal or other non-conventional fuels or sources of energy in its production, manufacturing, or processing operations. So it is also provided that the final product in the foregoing instances must involve or will involve substantial use and processing of domestic raw materials whenever applicable, taking into account risks and magnitudes of investment to be able to constitute as a pioneer enterprise, and provided further that the foregoing definitions shall not in any way limit the rights and incentives granted to less developed area enterprises. Under Article 28E of the Omnibus Investment Codes, it is provided that any of the declared preferred areas of investment, the board may designate as pioneer areas the specific products and commodities that meet the requirements of Article 17 of the Omnibus Investment Codes, as we have discussed a while back, and to review yearly whether such activity, as determined by the board, shall continue as pioneer. Otherwise, it shall be considered as non-pioneer and accordingly listed as such in the investment priorities plan or removed from the investment priorities plan. Under Memorandum Circular number 2015-01 as to equity ownership, it is provided that under the Constitution and under the Foreign Investment Acts of 1991, there are no restrictions on foreign ownership of export-oriented and or pioneer enterprise that will engage in the activities listed in the investment priority plan. So that's as to equity ownership. So we now go to the availment of income tax holiday bonus here, as provided also in the same memorandum, wherein the following will have the following may avail of the income tax holiday, particularly newly registered pioneer and expansion enterprises granted pioneer incentives, which may be granted one additional year of income tax holiday incentive for the following criterion. They must have a capital equipment to labor ratio criterion, a net foreign exchange earnings or savings criterion, and indigenous raw material cost criterion. Moreover, those with 6 years for projects with pioneer status and projects located in less developed area may avail of an income tax holiday. It shall likewise be fully exempt from income taxes levied by the national government. However, there are certain conditions for the income tax exemption, as also provided in the Omnibus Code. So subject to such guidelines as may be prescribed by the board, the income tax exemption will be extended for another year in each of the following cases. First, if the project meets the prescribed ratio of capital equipment to number of workers set by the board, there is utilization of indigenous raw materials at rates set by the board, and the net foreign exchange savings or earnings amount to at least 500,000 US dollars annually during the first 3 years of operation. However, under the preceding paragraph, no registered pioneer firm may avail of this incentive for a period exceeding 8 years. Moving on, we now go to who are qualified to avail of the pioneer status. So if the preferred activity is manufacturing, then any of the following may qualify for pioneer status. Projects on the manufacture or assembly of alternative fuel vehicle and electrical vehicles, wherein alternative fuel vehicles include hybrid vehicles and flexible fuel vehicles. So we also go with manufacture assembly of brand new 3 or 4 wheel Philippine utility vehicles for cargoes and or passengers. And lastly, the original equipment manufacturer or OEM parts and components may also qualify for pioneer status. Moreover, if the preferred activity is energy with respect to power generation plants, power generation projects located in missionary areas or off-grid areas may also qualify for pioneer status. Moving on, if the preferred activity is public infrastructure and logistics with respect to water transport, RORO operator and or enterprise serving missionary routes as indicated in the Certificate of Public Convenience issued by Marina may also likewise qualify for pioneer status. So we now go to the second type of investment, which is the non-pioneer area of investment. And we will first define what a non-pioneer enterprise is under Article 18 of the Omnibus Investment Code of 1987. So a non-pioneer enterprise shall include all registered producer enterprise other than a pioneer enterprise. So under Memorandum Circular number 2015-01, a non-pioneer enterprise may also avail of an income tax holiday bonus year, provided that it is a newly registered non-pioneer enterprise granted pioneer incentives. It may be granted an additional year of income tax holiday incentive for each of the filing criterion as mentioned before, capital equipment to labor ratio criterion, a net foreign exchange earnings or savings criterion, and an indigenous raw material cost criterion. Also, 4 years for new projects with non-pioneer status already may avail of an income tax holiday. So if pioneer status requires 6 years of new projects with a pioneer status, in non-pioneer enterprise, it requires only 4 years for new projects with a non-pioneer status to avail of an income tax holiday bonus year. It shall likewise fully exempt such non-pioneer enterprise with income taxes as levied by the national government. So that ends our topic on the different types of investment, particularly the pioneer and non-pioneer areas of investment. Thank you very much for listening, everyone.
Good afternoon, classmates. So today I'll be discussing the assigned topic to me, which is the Investment Priorities Plan, which was approved last November 2020. So first, what is an Investment Priorities Plan? The IPP is the government's blueprint of priority economic activities that qualify for fiscal incentives. It is an annual planning document, outlines various investment areas that the Board of Investment has identified as preferred activities and would help sustain economic growth and drive infrastructure development of the Philippines. So how frequent does this IPP being issued? And every year, the Philippine Board of Investments, or the BOI, draws up an investment priorities plan as required under the Omnibus Investment Code of 1987 and submits this to the Cabinet and the President for approval and implementation. So the following are contents of the 2020 Investment Priorities Plan, and under its preferred activities for investment, one of the enumeration of preferred activities is that all qualified activities relating to the fight against COVID-19 pandemic, and this covers essential goods and essential services. Under this essential goods, this covers the production or manufacture of medicines, medical equipments and devices, personal protective equipments or the PPE, surgical equipments and supplies, laboratory equipment and its reagents, medical supplies, tools and consumables, such as sanitizers, other cleaning materials, and including production or manufacture of raw materials, semi-furnished or intermediate goods, and machinery and equipment for the use in the production of the said uh, products. And under its essential services, this covers the provision of services uh, which is not limited to crematoriums, health waste treatment and disposal, laboratories, test facilities, hospitals, and quarantine facilities. And another preferred activities is the investment in activities supportive of the programs to generate employment opportunities outside of congested urban areas pursuant to the Balik Provincia program and giving income tax holiday up to 6 years. Number 3, all qualified manufacturing activities, including agro processing. And this covers the manufacture of industrial goods and processing of agricultural and fishery products, including halal and kosher food, into first semi-furnished intermediate goods for production of other goods and finished products or consumer goods for final consumptions. And number 4, another preferred activities is in relation to agriculture, fishery, and forestry. And this covers commercial production of agricultural, fishery, and forestry products. It also covers nurseries, hatcheries, post-harvest facilities, and other support services and infrastructure. Another preferred activities is the strategic services, which composes of IC design, which covers the logic and circuit design techniques required to design integrated circuits, creative industries or knowledge-based industries, and this covers services for domestic market and those involved in original content such as animation, software development, game development, healthcare, information management systems, and engineering design. Uh, it also include the maintenance, repair, and overhaul of aircraft and cleaning or rather charging or refueling stations for alternative energy vehicles. And under this letter D, it discovers the establishment of charging refueling stations for alternative energy vehicles except LPG run vehicles. And another under strategic services is the industrial waste management. This covers the establishment of treatment facilities for toxic and hazardous waste from an industrial operation. Another is in relation to telecommunications, which covers the establishment of connectivity facilities for fixed and mobile broadband services, and also they allow new players to can be qualified for a new registration. Another is the state-of-the-art engineering, procurement, or construction. This covers engineering design, procurement, and construction for industrial plants and infrastructure. And another is mass housing. Uh, This covers the development of mass housing unit based on a price ceiling, which is not more than 2 million pesos, and also in city low-cost dwelling projects for lease or rent. Another is for infrastructure and logistics, and this covers the establishment and operation of physical infrastructures vital to the country's economic development and prosperity, such as but not limited to airports, seaports, transport, and regasification facilities, pipeline projects for oil and gas, and bulk water treatment and supply, training facilities, testing laboratories, and domestic industrial zone. Another under strategic services are the innovation drivers, which covers research and development activities, conduct of clinical trials, establishment of centers of excellence, innovation centers, business incubation hubs, smart cities and fabrication laboratories, or and development of mobility solutions and digital trade. Another in the enumeration is inclusive business models. This covers business activities of small and large enterprises in agribusiness and tourism sectors that provide business opportunities to micro and small enterprises, or commonly known as MSEs, as part of their value chains. Another priority project under strategic services is the environment or climate change related projects, which covers the manufacture or assembly of goods and the establishment of energy efficiency related facilities. And lastly, on under energy, which covers power generation projects utilizing conventional fuels such as coal, diesel, bunker, and natural gas, waste heat and other wastes, and the establishment of battery energy storage systems. And these are the enumerations of the priority project under the 2020 Investment Priorities Plan. And with that said, the 2020 IPP mandates the Board of Investments to ensure that the grant of incentives is consistent with the policies under the Bayanihan to Heal as One Act and the Bayanihan to Recover as One Act, and other laws which granted the President special powers to defeat the coronavirus disease 2019, or the COVID-19 pandemic. And thank you, that's all.
Good afternoon, everyone. The case assigned to me was the case of Congressman Garcia versus the Board of Investments. Let me just share my screen. So in this case, Petitioner Garcia is the congressman of the 2nd District of Bataan who assails the approval by the Board of Investments and the Department of Trade and Industry of the amended application for registration of the Bataan Petrochemical Corporation, which seeks to transfer the site of its petrochemical complex from Bataan, the original situs of choice, to the province of Batangas. Proclamation number 361, as amended by Proclamation number 630, reserved a 388-hectare parcel of land of the public domain located at Lamau, Limay, Bataan for industrial estate purposes. PD 1803 likewise enlarged the area by 188 hectares, making it a total of 576 hectares reserved for the petrochemical industrial zone under the management, administration, and ownership of the Philippine National Oil Company. The Bataan Refining Corporation, BRC, is a wholly government-owned corporation located in Bataan, which produces 60% of the national output of naphtha. Taiwanese investors in this case was in a petrochemical project formed the Bataan Petrochemical Corporation, BPC, and applied with the Board of Investments for registration as a new domestic producer of petrochemicals. Its application specified Bataan as its plant site. Eventually, BPC was issued a certificate of registration on February 24, 1988 by the Board of Investments. BPC was then accorded pioneer status and was given fiscal and other incentives by the BOI. As an additional incentive, the House of Representatives approved a bill which introduced by the petitioner, in this case, Congressman Garcia, eliminating 48% ad valorem tax on naphtha if and when it would be used as a raw material in the petrochemical plant. The chairman of the BPC, Tomas TNC, profusely welcomed the bill. However, in 1989, A.T. Chong, the chairman of USI Far East Corporation, which is one of the major investor in BPC, personally delivered to the DTI Secretary Jose Concepcion a letter advising BPC's desire to amend the original registration certificate of its project by changing the job site from Limay, Bataan to Batangas. And one of the major reasons of such site transfer was due to the insurgency and unstable labor situation in Bataan. The presence in Bataan of a huge liquefied petroleum gas or the LPG depot owned by Pilipinas Shell Corporation was another consideration. So Congressman Garcia, in this case, vigorously opposed the transfer of the proposed petrochemical plant to Batangas. Even President Cory at the time also expressed her preference that the Bataan petrochemical plant be established in Bataan. However, despite such oppositions, BPC still filed in the BOI on April 11, 1989, a request for approval of an amendment of its investment application for establishing a petrochemical complex in the Philippines. So the amendments to the application consisted of increasing the investment amount from $220 million to $320 million, increasing the production capacity of its naphtha cracker, polyethylene plant, and polypropylene plant, changing the feedstock from naphtha only to naphtha and or liquefied petroleum gas or LPG, and transferring the job site from Limay, Bataan to Batangas. So on May 4, 1989, Petitioner Garcia addressed a letter to the Board of Investments Vice Chairman and Manager Tomas Alcantara requesting for a copy of the amendment reportedly submitted by the Taiwanese investors together with any and all attachments to said original application and amendments thereto. In May 21 of the same year, Alcantara informed Petitioner that the Taiwanese investors declined to give their consent to the release of the documents requested. In May 25 the same year, the BOI approved the revision of the registration of BPC's petrochemical plant. So in June 26, also of the same year, petitioner filed a petition for certiorari and prohibition in the Supreme Court with a prayer for a preliminary injunction alleging that the Board of Investments and the DTI gravely abused their discretion. So the issue in this case is whether or not the BOI and DTI gravely abused their discretion, first, in not observing due process in approving without a hearing the revisions in the registration of the BPC's petrochemical project. Second, in approving the change in the site of BPC's petrochemical plant from Bataan to Batangas. Third, in refusing to furnish the petitioner with copies of BPC's application for registration and its supporting papers. We also have an issue here where DTI and BOI gravely abused their discretion in approving the change in the feedstock from naphtha only to naphtha and or LPG and in showing gross partiality with BPC. So the Supreme Court ruled that it will not concern itself or it will not delve into the economic, social, and political aspects of the case. Since it does not possess the necessary technology and scientific expertise to determine whether the transfer of the proposed BPC petrochemical complex from Bataan to Batangas and the change of fuel from naphtha only to naphtha and or LPG will be best for the project and for our country. So the Supreme Court ruled that it is mainly concerned with the alleged violation of due process and the alleged extra limitation of power and discretion on the part of the public respondents in approving the transfer of the project to Batangas without giving due notice and an opportunity to be heard to the vocal opponents of that move. So the Omnibus Investment Codes of 1987 requires the publication of applications for registration, hence payment of publication and other necessary fees prior to the processing and approval of such applications. As provided by the law, the BPC's application for registration as a new export producer of ethylene, polyethylene, and polypropylene was published in the Philippine Daily Inquirer. However, BPC's amended application, particularly the change of location from Bataan to Batangas, was not published. And since BPC's amended application was not published, the effect of such failure to publish will deprive the petitioner of due process, and it will amount to grave abuse of discretion on the part of the Board of Investments. So under the Omnibus Investment Code of 1987, it mandates the holding of consultations with affected communities whenever necessary, meaning that whenever necessary, the Board of Investments, through the People's Economic Councils, shall consult the communities affected of the acceptability of locating the registered enterprise within their community. The provision in the investment codes requiring publication of the investor's application for registration in the Board of Investment is implicit recognition that the proposed investment or the new industry is a matter of public concern on which the public has the right to be heard. And the public must also have the right to be consulted, especially if the project affects their community. So when the BOI approved BPC's application to establish its petrochemical plant in Limay, Bataan, the inhabitants of that province, particularly the affected community in Limay, and the petitioner, Congressman Garcia, herein as the duly elected representative of the second district of Bataan, acquired an interest in the project which they have a right to protect. So in that case, since they have the right to be heard or be consulted on the proposal, it does require that the affected communities should be consulted. While the Supreme Court may not require the Board of Investments to decide that controversy in a particular way, they may require the Board of Investments to comply with the law and its own regulations prescribing such notice and hearing. So in answering the guide question as given in the module, an investor does not really have the final say in choosing the location for the business. Under this, as provided for by the Supreme Court, it holds that BOI committed a grave abuse of discretion in approving the transfer of the petrochemical plant from Bataan to Batangas and authorizing the change of feedstock from naphtha only to naphtha and or LPG for the main reason that the final say of the site transfer was given to an investor. So the petrochemical industry is an essential part of the national interest. The government superintends the industry by controlling the upstream or naphtha cracker facility. In this particular venture, not only has the government given unprecedented favors, but through its regulatory agency, the BOI, it surrenders even the power to make a company abide by its initial choice, a choice free from any suspicion and of unscrupulous machinations, and a choice which is undoubtedly to the best interest of the Filipino people. So the court now in this case granted the petition for certiorari, wherein the Board of Investments is ordered to publish the amended application for registration of the Bataan Petrochemical Corporation to allow the petitioner to have access to its records, but excluding, however, privileged papers containing its trade secrets and other business and financial information, and to set for hearing the petitioner's opposition to the amended application. So that wraps up the case for Garcia versus the Board of Investments. Thank you very much for listening.
This is the case of First Lepanto Ceramics Incorporated versus Court of Appeals, GR number 117680, February 9, 1996. The facts of the case are as follows. First Lepanto Ceramics Incorporated is the petitioner in this case, who is a domestic corporation registered as a non-pioneer enterprise with the Board of Investments with the purpose of manufacturing glazed floor tiles. And the condition of its registration is that the First Lepanto Ceramics shall export at least 50% of its production, and it should likewise produce only glazed floor tiles. And by virtue of its registration, First Lepanto Ceramics was granted non-fiscal and fiscal incentives by the Board of Investments, including exemption from taxes on raw materials and tax and duty exemption on its imported capital equipment. On the other hand, Mariwasa Manufacturing Incorporated is the private respondent in this case, which is a competitor of First Lepanto Ceramics and likewise registered as a non-pioneer enterprise with the BOI, to produce ceramic tiles. And on August 10, 1991, First Lepanto Ceramics sent a letter to the Board on Investments requesting for an amendment on its registered product from glazed floor tiles to ceramic tiles in order uh, to enable it to manufacture ceramic wall tiles. However, before the BOI would act upon the request of First Lepanto, Mariwasa and Phil Hispano Ceramics Incorporated filed a separate complaints with the BOI against First Lepanto for the alleged violation of the terms and conditions of its registration by the use of its tax and duty-free equipment in the production of ceramic wall tiles. Here, the BOI found the First Lepanto to be guilty and penalized it by imposing a fine for the said violation of the terms and conditions of its registration, and to whether consider the amendment of its certificate of registration. First Lepanto Ceramics then paid the imposed fine by the BOI, and it formally filed its applications with the agency to amend its registered product from glazed floor tiles to ceramic tiles. However, Mariwasa Ceramics Incorporated filed another verified complaint alleging that First Lepanto still continues to violate the terms and conditions of its registration, for it still continued the unauthorized production and sale of ceramic wall tiles. The BOI herein dismissed the complaint. However, Mariwasa Ceramics Incorporated still continued to oppose the amendment of the registration of First Lepanto. Thereafter, the BOI approved the amendment of the product registration of First Lepanto, and here Mariwasa Ceramics appealed the decision of BOI to the Court of Appeals. The Court of Appeals ruled in favor of Mariwasa, where it reversed the decision of the BOI and issued a preliminary injunction and TRO enjoining BOI and First Lepanto from enforcing the assailed ruling. Hence this petition. So the issues of this case is whether or not it is within the power of the BOI to grant the amendment on the certificate of registration of First Lepanto Ceramics Incorporated. And the Supreme Court ruled in the affirmative, where it granted the petition and likewise reinstated the decision of the BOI. It held that under Chapter 2, Article 7, Paragraph 8 of the Omnibus Investment Code, the BOI need not cancel the certificate of a registrant who is found to have infringed the terms and conditions of its registration. It further said that rather significant is the fact that to hold the BOI from taking action on First Lepanto's application would be to defeat the declaration of investment policies expressed in the law. And under Article 2 of the same code, it states that declaration of investment policies to accelerate the sound development of the national economy in consonance with the principles and objectives of economic nationalism and in pursuance of a planned economically feasible and practical dispersal of industries and the promotion of small and medium-scale industries under conditions which will encourage competition and discourage monopolies. The Supreme Court likewise discussed the powers of the BOI, where the BOI is the agency tasked with evaluating the feasibility of an investment project and to decide which investment might be compatible with its development plans. The exercise of administrative discretion is a policy decision, and a matter that can best be discharged by the government agency concerned and not by the courts. The BOI has allowed the amendment of First Lepanto's product line because that agency believes that allowing First Lepanto to manufacture wall tiles as well will give it the needed technical and market flexibility, a key factor to enable the firm to eventually penetrate the world market and meet its export requirements. The Supreme Court also reiterated the case of Felipe Ismael Jr. versus Deputy Executive uh, Secretary, where it states that while the administrative grapples with the complex and multifarious problems caused by unbridled exploitation of these resources, the judiciary will stand clear. A long line of cases establish the basic rule that the courts will not interfere in matters which are addressed to the sound discretion of the government agencies entrusted with the regulation of activities coming under the special technical knowledge and training of such agencies. And that's all. Thank you.
This is the case of First Lepanto Ceramics Incorporated versus Court of Appeals and Mariwasa Manufacturing Incorporated. Petitioner First Lepanto was registered as a non-pioneer enterprise with the Board of Investments. The certificate of registration provides that the enterprise shall export at least 50% of its production and that it shall only produce glazed floor tile. Private respondent Mariwasa, a competitor of First Lepanto, is also registered with the BOI as a non-pioneer enterprise, but the registered product is ceramic tile. So First Lepanto requested for an amendment of its registered product from glazed floor tiles to ceramic tiles. However, before the BOI could act on the request, Mariwasa and Phil Hispano filed separate complaints against First Lepanto for violating the terms and conditions of its registration by the unauthorized use of its equipment in the production of ceramic tiles. So the BOI rendered a decision finding First Lepanto for violating of guilty of violating its registration and imposed upon it a fine. So after paying the fine, First Lepanto formally filed its application with the BOI to amend its registered product. Mariwasa again filed a complaint alleging that First Lepanto continued to violate its registration by the continued unauthorized production and sale of ceramic tiles. However, the Board of Investments dismissed this complaint for lack of merit. So Mariwasa appealed to the Office of the President. So while this case was pending before the Office of the President, First Lepanto caused the publication of a notice on the official filing of the application for amendment. And this application was opposed by Mariwasa. But the Board of Investments handed its decision approving the application for amendment of First Lepanto. And this case was appealed by Mariwasa to the Court of Appeals. So in the Court of Appeals, uh, the Court of Appeals annulled the decision of the Board of Investments, stating that the Board of Investments should not have acted on the application, considering that there was still a case with the Office of the President. The Court of Appeals also stated that it does not have jurisdiction over decisions of the Board of Investments appealed to it. So the issues now are, number one, whether the Court of Appeals have jurisdiction over appeals from decisions of the Board of Investments, and number 2, whether the Board of Investments correctly acted on the application for amendment. So the Supreme Court ruled that the Court of Appeals has jurisdiction. The Omnibus Investment Code, providing for the direct appeal to the Supreme Court, is in violation of the 1987 Constitution, as it increases the appellate jurisdiction of the Supreme Court without its advice and concurrence. The Supreme Court also said that the Court of Appeals has jurisdiction over cases decided by the Board of Investments, as it is deemed to have been directly conferred to it by BP 129. The Supreme Court also held that the Board of Investments, in not acting on the application of First Lepanto's application, would defeat the Declaration of Investment Policies under the Omnibus Investments Code. The court noted that the Board of Investments is the agency tasked with evaluating the feasibility of an investment project and to decide which investment might be compatible with its development plans. The Supreme Court reiterated that courts will not interfere in matters which are addressed to the sound discretion of government agencies entrusted with the regulation of activities coming under the special technical knowledge and training of such agencies. So, in this case, the court should not interfere with the BOI decision allowing amendment of Certificate of Registration of First Lepanto. That's it. Thank you po.
I would be discussing the case of Enrique P. Garcia versus JG Summit Petrochemical Corporation. And by discussing this case, let us be guided with these two questions or two issues. First would be to discuss the Board of Investments requirement of publication and to resolve the legal standing issue in this case. Here, petitioner Enrique Garcia comes to the Supreme Court the third time already concerning a matter involving the establishment of a petrochemical plant in the country. In the first case that he filed involving a petrochemical plant, he was sustained by the Supreme Court that the amended application for registration of the Bataan Petrochemical Corporation or BPC must be published so that those opposing it might be given an opportunity to be heard. And in the second case that he filed concerning a petrochemical plant, the Supreme Court affirmed that the Board of Investments approval of the amended certificate of registration of the Luzon Petrochemical Corporation, which is formerly Bataan Petrochemical Corporation, should be nullified, by virtue of which the original certificate of registration with Bataan as a plant site and with NAPTA as a feedstock was ordered maintained. And now, in this third case, he wants the Supreme Court to declare whether PDIS numbers 943 and 1803, the law creating a petrochemical complex Ilimay Madahan, prohibit the establishment of petrochemical facility outside of it or outside of Limay Bataan. A. So the facts of this case would be as follows. JG Summit Petrochemical Corporation was registered by the Board of Investments as a new domestic producer of polyethylene and polypropylene resins, for which it was issued BOI certificate of registration. So as application, however, it was conditioned, it was required to submit to the Board of Investment the exact location of its plant, the execution plan. So at first, JG Summit informed the Board of Investments that its plant would be located in Barangay Alingalanan, Manjuyod, Negros Oriental. However, it later on advised the Board of Investment that it would be relocating to Simlong, Batangas City instead. The Board of Investment then caused the publication of JG's amended application for registration in a newspaper of general circulation to enable interested persons to file their sworn objections. Okay. And indeed, Garcia and the concerned residents of Barangay Silong submitted separate letters of opposition as to the registration or amended registration of JG Summit Petrochemical Corporation. So, Garcia, one of the petitioners and the main petitioner in this case, objected to the Batangas plant site, citing as basis the decision of this court in the second case, which annulled the board's approval of the change of plant site from Bataan to Batangas and of feedstock from naphtha uni to naphtha and or liquefied petroleum gas. So he argued that through that decision, this court now declared that Bataan Petrochemical Zone as the only possible site for petrochemical zones or plants as provided for under PDs numbers 949 and 1803. The Board of Investment dismissed the opposition of Garcia and approved the amendment of the JG's Summit certificate with Batangas as the plant site. So it ruled that the establishment of petrochemical plant Batangas does not violate PDs numbers 949 1803 and that in evaluating the choice of JG Summit as plant site, it considered other important factors such as the viability of the project and the cost, as well as the government's effort towards industrialization and development in various regions. And that in locating a petrochemical project in Batangas would be to would be to the national interest, as shown by a report submitted by the Stanford Research Institute, which was commissioned by the Board of Investments to undertake study of the petrochemical industry in the Philippines. So Garcia then filed, so without first filing a motion for reconsideration, he then filed a petition for review before the Court of Appeals, and it assailed the board's alleged reliance on the report of the SRI because allegedly Garcia was not informed of such a report. So, and he added that during the 50-day reglementary period for the filing of an MR or a motion for reconsideration, he actually tried to secure a copy of such a report, but to no avail. So that is what he claims. So in this petition for review before the Court of Appeals, JG Petrochemical Corporation now challenged the standing of Garcia to file the case absent any constitutional question therein. So it reiterated that the decision in the second Garcia case did not rule that petrochemical plants must be established in Bataan exclusively. So the Court of Appeals dismissed the petition for review filed before it. Hence, this petition now before the Supreme Court. In this, JG Summit maintains or it reiterates that Garcia does not stand to suffer any injury from the approval of the application, hence is not a real party in interest, and neither does he have standing to question its amended application because he is not challenging the same on the ground that it violates the Constitution. On the other hand, Garcia, the petitioner, submit that has a legal interest in determining the legality of locating respondents' land site in Batangas in light of previous numbers 949 and 1803. He then adds that the court has recognized actually his standing. The court already recognizes his standing because of the two previous cases that he had, so which are very similar in nature to the present petition because it concerns the petrochemical corporation in the country, and it basically um, has the same issues and subject matter to talk about. So he also claims that respondents is itself raising a constitutional issue. Such would be deprived of its right to use its property in Batangas should it be compelled to locate its plant in Bataan. So the issues in this case would be first is the change of land site from Bataan to Batangas violative of PD numbers 949-1803 and thus Garcia as a legal standing to file this case. So as with the first issue, no, the change of land site from Bataan to Batangas is not violative of PD's numbers 949-1803. A meticulous perusal of the two decrees reveals that nowhere in their provisions is it stated or can it be inferred that all petrochemical plants must be established in Limay, Bataan, or stated differently that Bataan is intended to be the site for all petrochemical plants to be established here in the Philippines. What is clear um, is that the law reserved an area for a petrochemical industrial zone in Bataan. However, there is nothing further in the law to indicate that the choice of Limay Bataan as a petrochemical zone was exclusive. On the contrary, the use of the word may in the provision of the law runs counter the exclusivity of the Bataan site because it makes it merely directory rather than mandatory to choose Bataan as a plant. And as to the second issue, yes, Garcia has a standing to file this case. The provision in the Investments Code requiring publication of the investor's application for registration in the Board of Investments actually an implicit recognition that the proposed investment or new industry is a matter of public concern on which the public, including Garcia, has a right to be heard. So the fact that there's a requirement for publication in order for those interested persons to file their oppositions is already an indication that it's a matter of public concern to which the public has a right to be heard or has a right to be informed. And when the Board of Investments approve BPC's application to establish its petrochemical plant in Limay, Bataan, as ruled in the second case that Garcia filed, the inhabitants of that province, particularly the affected community in Limay, and the petitioner herein as a duly elected representative, 2nd District of Bataan, acquired an interest in the project which they have a right to protect. So their interest in the establishment of petrochemical plant in their midst is actual, real, and vital because it will not only affect their economic life but also their health as to the air that they will breathe. And it cannot be gainsaid then that the provision of the Omnibus Investment Code of 1987 requiring publication of the investor's application for registration remains to be the source of petitioner's legal interest to oppose here in respondents' amended application because they will still stand to be affected economically and also um, in their health. So the fact it is noteworthy that the fact that the petrochemical industry is a preferred area of investment and conferred a pioneer status in the country's 1994 to 1996 investment priorities plan underscores its importance to the economy. So during this time, the petrochemical industry is important to the boosting of the economy. So the Supreme Court in a lot of cases has brushed aside technicalities of procedures and relaxed the rules of standing in cases of transcendental significance, especially where the issue or issues involved have important ramifications to the nation. So granting arguendo that that Garcia actually has no standing as claimed by no standing to file this case as claimed by JJ Summit, Petrochemical Corporation. The transcendental importance of the case and the significance of the issues raised herein are considered sufficient already to clothe him with legal interest because, as we have said a while ago, petrochemical industry is actually uh, a preferred area of investment and conferred as a pioneer status in the country's investment priorities plan. So it's actually important to the boosting of the economy. So even if assuming that Garcia has really no standing to file this case, the transcendental importance of the issue involved in this case would be sufficient now to clothe him with the necessary legal interest needed. So that would be all for this case. Thank you.
So for our takeaways for Module 4, let us remember that currently the Board of Investments for its BOI registered enterprises, BOI have compliance requirements so that they can verify the entitlement of these BOI registered enterprises to incentives, particularly income tax incentives. Together with the BIR, the BOI, and the other investment promotion agencies, they want to ensure that only those entitled to the incentives can enjoy them. So when required, there should also be compliance with the Tax Incentives Management and Transparency Act, or the TIMTA. Okay? There should be compliance with TIMTA reportorial requirements. To avoid issues in securing the certificate of incentives, the enterprise must ensure that it has complied with all the reportorial requirements. BOI registered enterprises are required to secure a certificate of income tax holiday entitlement, so certificate of exemption. Such certifications are required to be attached in the annual income tax return. So for BOI registered enterprises, a copy of the BIR received annual income tax return and audited financial statements are required to be attached to the BOI form S-1. So this is the annual report on actual operations. The form is required to be filed within 4 months after the end of the taxable year or April 30 for enterprises that follow the calendar year. Based on the BIR received audited financial statements and income tax return, Board of Investment shall validate on a per registered activity or project basis that the period covered by the annual ITR is covered by the income tax holiday or the 5% gross income tax incentive. It shall also determine the income that should not be covered by the income tax holiday or the 5% gross income tax, if any. To determine if the enterprises complied with the minimum or the maximum sales requirement, they shall also validate the actual percentage of export sales for export-oriented enterprises, low-cost housing sales for real estate companies, and other sales requirement as agreed for their registration terms and conditions. So that's the function of BOI. So what if, based on the BOI's evaluation, the enterprise actually failed to comply with the conditions for the income tax incentive? Can the BIR assess the enterprises based solely on BOI's evaluation? In a recent case that was decided by the Court of Tax Appeal, this is CTA case number 9553. The CTA ruled that the BIR cannot simply proceed to issue assessment notices based solely on the evaluation done by the Board of Investments. The enterprise's books of account and other accounting records must be independently investigated and considered by the BIR. According to the ruling, the BOI registered enterprise is required to have at least 20% of the total subdivision area or total subdivision project cost allocated and developed for socialized housing within 1 year from the date of registration. So this has something to do with the actual facts of the case. Otherwise, in that case, its income tax holiday incentive for the taxable year will be forfeited. Based on the BOI's evaluation, the enterprise failed to comply with the 20% socialized housing requirement. Thus, in several letters to the BIR, the Board of Investment declared that the grant of the income tax holiday incentives to the BOI registered enterprise has been denied. Relying only on the forfeiture of the income tax holiday incentive by the BOI, the BIR issued a preliminary assessment notice and a formal letter of demand assessing the BOI registered enterprise deficiency income tax and penalties. The BIR no longer issued a letter of authority to assess. The BIR in that particular CTA case decided did not also conduct its own tax investigation. Since no letter of authority providing the revenue officers or examiners with the authority to examine the BOI registered enterprise and to recommend an assessment was issued, the assessment was considered in that particular case null and void. Though it may be clear from BOI's evaluation that the BOI registered enterprise was not entitled to the income tax holiday incentives for that taxable year, the BIR should have conducted its own investigation to verify the facts for its assessment to be valid. Nonetheless, should the assessment in that case was considered invalid, BOI's results of validation of income tax incentives may still be a basis for the BIR to initiate or to conduct its own investigation. Thus, every taxpayer enjoying income tax incentives must always ensure that it complies with the BOI's conditions for the grant of the incentives, continuing compliance. It must also ensure compliance with Board of Investments and BIR reporting requirements as discussed previously. So it must obey rules. Okay. So taxpayers must obey rules like a child to ensure that it fully enjoys the rewards and benefits of the tax incentives it was granted. So takeaways: apply, get registered and certified to avail of incentives. The grant of incentive is not automatic. There must be a positive act on the part of the person wanting to avail of it. The reason why you have to obtain a certificate of exemption, and the grant of the incentives when availed is subject to continuing compliance with lawful requirements pursuant to law, rules, and the conditions for certification. So after all the videos that was shared today, remember this.
Workspaces, technology, and infrastructure make up a business. But it takes the right people in the right place for a business to succeed.
We are Transcom Worldwide. We've been in the Philippines for 10 years.
We're Mode Controls Corporation. We just celebrated our 30th anniversary.
Our company is Continental, established 40 years ago.
My company is Unilever. We've been here for over 88 years.
The working skills and traits of our Filipino workers are that they are very highly educated, very knowledgeable, very dedicated.
We love the Filipino employees. Philippines has the highest literacy rate in the world. 95% of our employees are college graduates, so it's easy to give them the skills.
The learning curve of the Filipino employees is quite fast, and that makes it easy to work with them.
They also tend to be Western in the outlook while being Asian, and that allows them to connect with other influences quite easily.
Our Filipino workers, speaking as fluent English as they do, makes it very easy to work, to communicate with our partners around the world.
The difference with Filipinos is that they listen and they hear what isn't being said. That and the English proficiency makes them the best in the business.
Best in Asia.
With a population this large and strong, anything is possible for your business.
The right people make all the difference. Your business, our people. Invest in the Philippines.
So that will be all for Module 4. See you next week for your first quiz on investment and incentive laws. Have a blessed weekend, everyone. Bye.